Today we will be discussing the justification defence, also referred to as the journalistic material defence. Our discussions will surround the UK case of Naomi Campbell against Mirror, with particular focus on how the defence differs between Australia and UK. Firstly, let's talk about what happened in the Naomi Campbell case. It was a front-page story about an international supermodel named Naomi Campbell. It was entitled, "I Am a Drug Addict." There was a supporting image of Naomi entering a Narcotics Anonymous meeting, which was captured by an undercover freelance photographer. So it's important to note that Naomi had rejected all imputations that she suffered a drug problem. This is a vital factor that was considered by the Lords of Appeal when they made their decision. In their majority judgment, Baroness Hale and Lords Hope and Carswell held that Mirror News was liable for a breach of privacy because the accompanying photograph added something of real significance. They used the balancing test to weigh up Campbell's reasonable expectation to privacy and whether her being successful would result in significant interference with freedom of expression. In their dissenting judgment at paragraph 12, Lords Hoffman and Nichols held that Mirror News were allowed to publish the articles and the pictures were within the margin of appreciation, particularly because Naomi had been defending the drug abuse claims quite publicly. This is the introduction of the justification journalistic material defence. So, was the content published justified, taking into account the surrounding circumstances? The United Kingdom's approach to the journalistic material defence differs to Australia, and here's how. The UK follows the European Convention of Human Rights, which includes the paramount right to privacy. This was the main consideration in the Campbell case. The right to privacy is also combined with the approach by Chief Justice Gleeson in ABC against Leonard Game Meats. At paragraph 42, where he used a test to determine the ambit of a person's private life. This involves looking at the degree of intrusion of privacy and the extent that the matter was a public concern. Moving on to Australia's position. In Australia, only Victoria and the ACT have enacted bills that refer to a right of privacy. In the remaining Australian jurisdictions, there are no formal legislative guarantees of protection for freedom of expression, although all of Australia does have a right to freedom of political opinion under the Australian Constitution. Australia's official position on the justification defence lies within common law, where a court must decide whether the media and journalistic activity offers significant public benefit. If it does, then the material is considered to fall within the scope of the journalistic material defence. A classic example of this is Julian Assange and WikiLeaks. However, the courts noted in Lang against ABC that the defence should not be unrestricted and it shouldn't apply in all circumstances. It won't apply in circumstances where the material is journalistic in nature, the matter is trivial, or it's merely for gossip. So the main differences here are there's not a huge difference in terms of the common law tests. However, UK has implemented a formal legislative right, and Australia relies on common law and public significant benefit.